So sentencing set for Wednesday. Cheryl, your reaction?
Not surprised. I mean, I think at this point the judge has a pretty good idea of what she is planning to do. Both sides get to present what they will ask her to do for sentencing purposes. Prosecution will give their opinion on what he should be sentenced to. The defense will give their opinion on what he should be sentenced to. And what she was talking about there are the victim impact statements. So on his mother, the children, whatever impact statement could come through them. I think last week she was talking about DCF having those statements available for her to be able to pass sentence on, whenever the trial ended, which ended up being a lot quicker than most of us realized.
So the difference between murder 1 and murder 2 is premeditation. The difference in the penalty is the chance of parole, correct?
Right. Murder 2, you have the chance of parole, the opportunity to be paroled. In murder 1, that's something that it's life without the possibility of parole.
This was unique in that it was a no-body case, which we talked about. The jury seemingly did not have an issue with that.
No, and it looks like, the prosecution asked them to connect the dots. They said, okay, here's the case, here's what happened, here's our version of what happened. And they connected the dots and got to, premeditating, believing that he planned this. And, we saw all of the evidence about the aftermath, how he purchased the items at the store and how he got rid of the rug and all of the things that were dumped in dumpsters, parts of her body, her clothing. But you didn't hear much about the premeditation part of the case. We heard that he knew that she was having an affair. We knew that, based on the evidence that came out during the trial, that he also had asked for the day to do errands and to tell his parole officer that he needed to do those things, because don't forget, he has a federal trial.
He was under house arrest for the previous charges of trying to sell the Andy Warhol fake paintings.
Right, and that's a federal case. That's separate from this case. So piecing all of that together, this jury got to the point where they believed that he premeditated the murder, but we don't know how the murder happened. We don't know the cause of death. We don't know how she died or exactly when she died.
Yeah.
So it's interesting in this case. That's unusual. Usually in murder cases, you know how they died.
Okay.
All right.
You said unusual, and I want to follow up with legal analyst Jennifer Roman, who's joining us, because she had told us earlier when we spoke to her that this trial was marked with surprises, starting with 2 surprise guilty admittances, pleas by the defense, and then the fact that they rested their case without calling any witnesses. Jennifer, what do you make of all of this that's transpired in this trial?
Wow. This was a huge win for the prosecution, not having a body, not having a cause of death, having some evidence of premeditation, but nobody who could really close the loop on that. And then for the jury to come back so quickly, it was very clear to these jurors, just sort of listening to the testimony, reviewing the evidence, and just speaking for not very long. They only deliberated for a few hours to come back with this guilty on a first-degree murder charge. Was a huge win for the prosecution.
It was. And Jennifer, just for the defense, do you think it was just too much for the jury to accept the picture they tried to paint of a husband who found his wife unexpectedly dead, and then his decision was to dismember her body out of fear that he would be accused right off the bat? Do you think, in light of the video evidence of him buying the supplies and all of the rest of it, the photo of her on the rug, do you think it was just too much for the jury to accept?
Yes, clearly. I mean, the prosecution's job is to prove beyond a reasonable doubt. And the jury had to question, was it reasonable that she fell into that 5 to 10% of people who just die unexpectedly? Was his conduct after he allegedly found her dead in their bed reasonable? Is that what a reasonable person would have done? Would a reasonable person have gone on Google and Googled the best ways to dispose of a body, and then purchased all of these supplies and weapons to dismember her, and ultimately that very compelling surveillance video of him making multiple trips to dumpsters after she has been killed? Just not reasonable.
Yeah.
We should point out the mother of his 3 children.
Yeah, absolutely.
So this is the person we're talking about, that he would choose to do that.
It is a stark case. I want to put this up for both Cheryl and Jennifer. When we talk about this and the way this trial played out, Cheryl, how much does a client affect the defense strategy in a case like this? How much can they put their foot down, or how much are they in the passenger seat because it was unorthodox?
Well, I mean, ultimately, it's the client's case. It's their life that's on the line. So while the defense attorney will present what they believe to be a good strategy and how they think that the case should be tried, but ultimately it would be the client's decision to say, I want to plead guilty, or I want to do this instead of that. And those are ultimately the client's decisions.
Yeah, and Jennifer, same thing to you. When you see a case like this, do you feel, in your experience, that the client may have had some input into how the defense proceeds?
The client had a lot of input in how the defense proceeds. And the fact that the defense counsel essentially promised us that Brian Walshe was going to testify at opening, and then 3 weeks later, they don't call any witnesses. It appears to have been like a 180-degree shift on the defense strategy that I can't help but think Brian Walshe ultimately said, I'm not getting up there.
Yeah, I think the judge even seemed surprised that especially he did not testify in the end. So moving on to sentencing on Wednesday, the judge pointed out the victim impact statements are extremely important. And for those of us lay people, for a judge who has certain parameters, but will a victim impact statement or several of them affect their feeling during sentencing? Jennifer, let me let you answer first.
Sure. There's a mandatory sentence here, life without the possibility of parole. So where the victim witness impact statements could influence the judge is on the 2 lesser charges that he pled guilty to at the start of the trial. That could influence how she ultimately adds on to his life sentence with those 2 lesser charges.
Yeah, and of course those 2 lesser charges were part of a plea agreement made before we even heard opening statements. It was lying to investigators and conveying or moving a body illegally, Cheryl. So that on top of the life sentence?
On top of the life sentence, to the extent that there is an on top of the life sentence, right? I mean, if it's life without the possibility of parole, which is what he is facing, and he's also facing those other federal charges, I mean, it looks quite unlikely that he would be getting out of prison. I mean, there's an automatic appeal on, first-degree murder charges, too.
Sure.
Interesting.
Sure.
Yeah.
It's interesting. I just think for observers of a case like this, when you talk to judges about past cases, will they talk to you about how victim impact statements hit them, how it makes them feel?
I think, when, as what she was looking for is, she wants to know how this is affecting the Anna's mother, the children, as we said, as a result of the other charges which he already pled to. And yes, I think it does. I think it does influence the amount of time that they believe might be appropriate in those particular cases. And it's case by case, and the type of charges, and the type of impact that it's had on victims.
Well, and Jennifer, I thought in a no-body case, sentences like this are meant to send a message, right, to this culture at large. Someone might look at this and think, well, if I murder someone and get rid of the body, there's no way I'll be convicted. And this sends a clear message, doesn't it?
It certainly does. I mean, the old school thinking is you could not prove murder without a body and without having a cause of death. And now with advances in medical science and surveillance and Google searches, as we saw here, that can all link somebody back to a murder without a body.
Yeah. Hey, Jennifer, your first words were big win, and you said it emphatically. I want to pull back from about 30,000 feet and look at the Norfolk County DA's office entering this trial beleaguered, bruised after the Karen Reed trial, with flack about former Inspector Proctor. They managed to pull through. What does this do for the office?
The DA's office, I think, kind of needed this win from a public appearance standpoint.
Yeah.
I think there has been some discussion that they tend to, maybe they're overcharging these people, and that's why they're not securing convictions. And this was one of those cases without a body, without a cause of death. I think people were questioning, should this have been a second-degree murder charge? But they got it. They convinced 12 people beyond a reasonable doubt that Brian Walshe not only killed her, but he premeditated that murder.
Yeah, Cheryl, you're nodding convincingly at that, too.
Yeah, I think that that's exactly right. I mean, I think that folks are looking at this saying, okay, if you're not winning cases, are you overcharging? Is that what's going on here? And this was a tough one to come out with a win for, first-degree murder. The evidence was very small for the, for the preparation, for the planning of it. Plenty of evidence on the tail end about what he did, with the video evidence, the searches, what he was buying at the store, on the tail end of how he disposed of the body. But at the beginning, the jury had to really piece all of the pieces of the puzzle together, and they managed to do that.
Sure, and Jennifer, you had pointed out that a lot of this evidence was after the fact, and people are used to watching TV crime shows where DNA evidence can be extracted from a drop of blood, and it just doesn't work that way. So this is a big win for that office.
For sure. This is a really big win for them.
Yeah. And speaking of what people are used to seeing on TV, it's usually that one statuesque attorney. But the Norfolk County DA's office had a team working. Describe what that's all about as far as different attorneys delivering opening, and closing that we saw, and then everything in between as far as who is going to question which witness.
Yeah, there's a lot of strategy that goes behind this. In big murder trials, there's a lot, many hours of work that go into preparing these cases, not only immediately before the trial, but from the very beginning in the investigation, the charging, then all of the pretrial hearings that happen. And I thought it was a really good strategic move here for the Norfolk DA's office to have two different attorneys, one arguing opening and one arguing closing. They had very different styles from each other. And I think that probably appealed to the jury. I think it probably held the jury's attention a little bit more than if they kind of knew what to expect because they had already heard openings from Attorney Tipton, for example.
Yeah.
Brian Walshe's demeanor was pretty calm when that verdict came down. And, when you look at a case like this, Cheryl, from beginning to end, as Chris pointed out, you wonder how much the defendant is playing into the strategy, what's going on in the mind of that person. And the jury clearly saw the whole picture here, and he must have had a good handle on the fact that this is what was going to happen.
Well, I mean, just, the fact that he didn't testify, even though it was promised that he would, and get out there and tell his story. I think at some point during the trial, he decided that that wasn't going to be a good thing for him to do, and he decided against it. Whether it would have made a difference in this case, who knows?
Yeah.
Yeah. Well, our Penny Commit has been in the courtroom following every aspect of this case, and she has been updating us on, her observations in the courtroom have been interesting. The various, dress one day or demeanor another day. And this one really did wrap up so quickly. And having no witnesses testify for the defense.
And I'm looking over Penny's notes right now. She kept very thorough notes. She'll join us in a few minutes. But very few questions, I think, if any, asked by the jury. What does that tell you?
Yeah.
Well, I mean, I think that they probably had a pretty good idea during the course of the trial what they wanted to do and what they needed to know more about, or if they needed to know more about anything. I mean, don't forget the burden of proof and what is the prosecution's to prove beyond a reasonable doubt all of the elements of the crime. And that's something that they have to do. The defense doesn't have to do anything. They don't have to put on a defense. They don't have to cross-examine any witnesses. All they have to do is say that the Commonwealth hasn't proved its case beyond a reasonable doubt. But, taking a look at this case, if you think about what the judge asked them to do, is use your common sense. Is this reasonable? And, in thinking that through, they obviously went back there and they were able to put the puzzle together and say that what they thought was reasonable and what they thought, using their common sense, what the verdict that they reached.
I know what I wanted to ask, Jennifer. When you talk about how technology has changed the way some of these cases will be prosecuted moving forward, in terms of Brian Walshe using his son's iPad, for instance, probably trying to use some device not associated with him, or so he thought, and making Google searches. What will legal scholars and the law moving forward do with cases like this now, where there's more surveillance video everywhere we go? Of people coming in and out of stores. We've got Google searches. There must be a whole new part of the legal landscape that is going to start to focus on this aspect of prosecuting a case.
Definitely. I mean, just the forensic data that can be pulled from somebody's computer, their phone, from an iPad, it's almost endless. And this case is one of those cases where the technology really, I think condemned him. Not only did we have those horrible, macabre Google surveillance footage that, she said, everywhere we go now, we could be on surveillance. And the fact that the police were able to pull all of that surveillance, get download the Google searches so quickly, it's only going to get faster, right? Their ability to close that and secure that evidence is only going to get faster as technology advances.
Yeah, Jennifer, we just put a live image of the courtroom, outside the courtroom when you were speaking, trying to get some comment from the defense attorney in this case. He walked briskly away, unsurprising there. Will we have an opportunity? Will Brian Walshe have an opportunity to say anything?
He will at sentencing. He has the opportunity to speak. His lawyers will speak on his behalf, obviously, and give their sentencing recommendations. But he's more than welcome to speak. And some defendants do, some do not.
Yeah. Any illusion as to whether he may or not?
I almost think that he might at this point, but we've been wrong before. We really thought he was going to take the stand in this case and be able to say what he wanted to say, but he decided not to take that chance. At this point, it looks like his fate is sealed as far as life without the possibility of parole. That's already going to happen. As to whether or not anything he says at this point would influence any sentence, probably not, unless he wants to make some type of an apology or say something more about what's happened here.
Yeah.